This is Michael Cowen, and welcome to Trial Lawyer Nation.
He helps us pan for the gold inside ourselves.
You need to have grit. I mean, a lot of this is grit.
I feel like I've been made a better lawyer.
They're talking about something that's real to them.
You have to be really careful not to be Goliath.
They saved a bunch of lives and changed society forever.
But let's just begin the conversation.
Welcome to Trial Lawyer Nation, your source for guidance to win bigger verdicts, get more cases, and manage your practice. And now, here's your host, noteworthy author, sought-after speaker, and renowned trial lawyer, Michael Cowen.
Today on the show, I have my partner, Sonia Rodriguez. Sonia is joining me for another Table Talk episode. When we created the podcast, we wanted to share information that would help you with your practice as a trial lawyer. And we've asked you guys to email in requests for topics you'd like us to cover. One topic we've got a lot of requests on is how to handle defense medical, what they call experts, or I call paid opinion witnesses. And so Sonia and I are going to talk to you about some of the things we've done, and I hope it's helpful to you in your practice. Good morning, Sonia.
Morning.
So today we're going to talk about what the defense calls defense medical experts, what I call paid opinion witnesses. And just talk about some things we've seen that work and don't work with the defense medical witness. And I mean, this is such a sham. I mean, we have these people, they call themselves independent medical examiners. They're not independent. They're picked by the defense lawyers and the insurance companies. We know what their reports are going to say as soon as we hear the name. We still read them, but every client has pre-existing degenerative changes. Every client has no acute traumatic injury, or if they do, that it was fully resolved and no further medical treatment is needed. And it's the same case after case after case. I think it's a huge fraud that's being perpetrated on our clients and on the jurors and the court system. But what do we do to expose this and to show the jurors the truth?
Well, I think it's super critical that we really get into the relationships that the experts have with the lawyers who've hired them, how often they've been used by that firm or by the defense industry, how much money they make from that business, what percentages of their practice are dedicated to reviewing files for defense lawyers versus actually practicing medicine. I think that goes a long way in exposing these witnesses for what they are, which is, paid defense expert witnesses.
Yeah, and like I said, I don't like that term even expert because I don't want to give them the mantle of authority of expert. Keith Bitnick in his book, Don't Eat the Bruises, uses the term paid opinion witness. And I think that's really the most accurate term to use because they are getting paid to give an opinion that will help the people paying them. There's people that stand on the street corners that pay you to love them, and they're the people that you can pay to love your case, and that's what they are. I know I'm being a little extreme out there, but that's really, it really bothers me to see someone misuse a medical degree to, instead of doing no harm, to actually try to harm legitimately injured patients for money. I mean, it's as bad as it gets. I think definitely exposing that relationship, I think you're right, in exposing the financial ties, the bias. I also think going in, and it takes some work, and sometimes, we see these people all the time. Sometimes what you're getting in your deposition is to set up your future depositions. You're not necessarily going to get it all the first time. But going in and discovering why is this doctor, instead of treating patients, reviewing medical records, meeting with defense lawyers, and giving opinions in lawsuits. What caused that doctor to do that?
Right, there's no doubt that the doctor would likely be making more money if he or she were in private practice. So the fact that they're sitting in a room reviewing medical records tells you something about their business choice.
Yeah, it depends on their private practice. A good surgeon would make a lot more money doing surgeries than reviewing medical records, but a doctor that just has an office practice because no one will refer surgical patients, or a doctor that for some reason can't do a surgery anymore, that's a whole different story. Have you ever discovered anything interesting on these doctors' backstories?
Well, I think that some of the things that you can get on their backstories is not so much, I've never really discovered anything, that they're making a living doing something solely for reviewing cases, but one thing that you do, if you dig deep enough, you can find flaws in their practice when it comes to the part of their business that's dedicated to reviewing medical records, and then their small part of their practice that's dedicated to reviewing patients. To meeting patients. There's an infamous case in Bexar County where a doctor actually treated a patient as a treating doctor, and then because of poor checks and balances in his own office, ultimately a few years later actually authored an opinion that the surgery that he previously had recommended for her was not needed. And so there wasn't a conflicts review in his office, and it made him really look bad when there was a report that he treated her and said she needed surgery as a result of this car wreck. And then a couple years later, the opinion was completely different when it was paid for by the defense.
Yeah, that's frightening. Yeah, I've also found the reason, and I'll give an example. There was a doctor that gives opinions throughout the state of Texas. He's calls himself a surgeon, but he doesn't do surgeries anymore. Why? Well, he had asymptomatic pre-existing degenerative changes. Sound familiar to our cases? Mm-hmm. He's riding a jet ski. He hits a wave too hard. He ends up needing a 5-level fusion, and as a result of the radiculopathy that wasn't, which is the nerve problems that weren't completely solved by this 5-level fusion, he could no longer do surgeries, and then he started making a living testifying in lawsuits and reviewing papers for insurance companies. Well, his story is a lot like the story that our clients go through. I mean, they have natural aging processes, which the defense calls degenerative changes, and they are exposed to trauma and then they're hurt. But it's interesting that when the doctors, and you'll find this with many of the defense doctors, they go into it because they have some kind of injury or problem where they can't do surgery anymore. It was legitimate for them, but then when they get paid on the other side, it's not. And just telling that story, it's a real world example that what happens to our clients happens in the real world.
Well, I think that, telling the story of why the defense paid experts are doing what they do is probably a long game. You're not, like you said, you're not going to get that information right in one deposition, which is why it's so important to cull any depositions where that witness has testified before, become member of your local trial lawyer association, your local trial lawyer association, and find everything you can on that witness, because there may be 1 or 2 nuggets of information that witness testified 2 years ago that you're building on to actually tell the story of why this doctor isn't actually treating patients anymore.
And I got all this from other lawyers and then built on it on the cases where I found the background of the doctors.
Right. And if you're reading a deposition, a 2-year-old deposition with a critical eye towards telling this underlying story, you're going to pick up on answers that weren't followed up on because, the previous lawyer may not have been looking to tell that story. So it's kind of fun to go back and look at old depositions and scour for what it is that you think you might be finding in the way of dirt on a witness.
And not just dirt, but you've had an interesting one recently where you networked and found a deposition where the doctor was testifying regarding one of his own patients as opposed to being hired as a defense paid opinion witness.
One of the reasons that I love trial lawyers is that by and large we're team players, and I made a call and asked a lawyer for a deposition that I'd seen on a listserv he'd taken of a witness, and within 6 hours he'd sent me the complete deposition of the doctor I was deposing, and it was a watershed moment in the case because that doctor had completely forgotten about the deposition he'd given in that previous case, and ultimately I let him testify for about an hour without springing that deposition on him. So it wasn't until I had him nice in the box in the corner that I sprung this previous deposition, and there was no way he could get out of it. And so, but for this, local San Antonio attorney who was generous enough to dig through his file and email me right away when I asked, it wouldn't have gone the way that it did.
But basically his opinions were the opposite when it was his patient than they were when he was getting paid by an insurance company.
Right. In the previous case, he treated an elderly woman with degeneration that he said were degeneration. Despite all of the signs that he called degeneration, he opined in that prior case that her surgery that he was recommending that he do was caused by a car wreck. And so fast forward 3 years, and he was now being paid as an expert in a case, paid to give an opinion in the case, and he had a much younger woman with signs of what he called degeneration that he refused to say were caused by a car wreck. So it was interesting to see him try to wiggle out of that.
Yeah, networking it's good to network with other lawyers, get on listservs, but I thought also networking with the doctors that will talk to us, like with our treating doctors, they often know the gossip on the defense paid opinion witnesses. And I know one, for example, there's one guy down in McAllen, Texas, we see on our cases all the time. And, we talked to some of our doctors, and he goes, yeah, he worked for us originally when he first came down here, and he was not a good surgeon. We would not send him anyone, and he's known in the medical community of not being a good surgeon. In fact, I don't think he's done a spine surgery in years. And then, when we asked the guy in his depot, he had to admit all his cases are spine cases where he's saying, you don't need spine surgery, you'd get better, it's all degenerative. He hasn't done a spine surgery since 1991.
Right.
And so, because he can't make money doing what surgeons do, because other doctors don't refer him clients or patients, he's had to go and then work for the insurance company trying to deny medical care, deny justice to people, because that's how he makes his living.
I think if there's any area of the personal injury practice where over preparation is still not enough, it is in this arena. I don't think that you can ever over prepare for a medical doctor's expert, because once you've got the medicine down, you can still pull their authorities. Once you've got their authorities scoured and cross-referenced and double-checked, and you can still pull their personal background information. I mean, it just can go on forever, but you can never over prepare for a defense medical doctor expert.
What do you mean by pull their authorities?
Well, one of the things that I've always found that is fun to do, this is a sick form of fun, right? But is to actually pull the tangible authorities that the defense paid experts are using to rely on, and go to the page in line and see if what they say actually does say what it says.
Absolutely.
And oftentimes you're going to find that it doesn't actually say what it says. Sometimes you may even find that it says the opposite of what it says. And then occasionally you will find that the sources of authority that they're using are not actually the authorities that the doctors are using today. It may be outdated, it might be an old edition, it might be from a different area of medicine. I can't tell you the number of doctors that I've had use the definition of radiculopathy that's used in the workers' compensation arena. And that's very different than the definition of radiculopathy that doctors use in their practice to treat patients. And so, really drilling down on their authorities and their I look at it as a table of contents. I just go through their reports and I highlight every single place where they rely on some tangible book, paper, or medical literature, and then I go pull it and see if it says what they say it says. It's no different than when we're in court and opposing counsel pulls an opinion. No lawyer would go into a hearing without pulling the opinion to see if it actually says what the opposing counsel says it says. And so there's no reason why we shouldn't be doing that exact same thing with these witnesses.
Absolutely. And sometimes you have to fight them to, they always want to say, what, this is well known, everyone knows this. I remember we had the radiologist down in South Texas, and he did his fellowship at Yale, so he was like the neuroradiologist, the man, and he testified really well at first, and so I knew I had to find some way to get him, because he was a professional witness. He stares at the camera, he never looks at you, He's got examples, and it's all BS, but he has a good dog and pony show. And so I was starting to get after him. I said, "Doctor, you say that you can tell by looking at the MRI that this is not from trauma because there's nothing white, basically. There's no fluid where fluid shouldn't be." He goes, "That's right. And that's your opinion. In every case I've ever had with you, you said because there's no like bright white things on the MRI that it's not from the car wreck." "That's right." "Okay, well, can you give me any magazine, book, article, anything in the whole world that supports your opinion?" And he said, "Well, they all do. They look at all." "Okay, well, Doctor, I'm going to tell you, I'm going to file a motion with this court saying that you're making things up and that this is not scientific. And you're one of the things you're going to have to do is have some kind of backup. Can you name any journal? I mean, you've got journals in your office. We have books in your office. Can you just go to the bookshelf and pull one book, magazine, journal article, paper, anything that supports your opinion?" And finally he goes, "Just get Scott Atlas MRI of the brain and spine. It's all over there. You'll see the pictures. It's exactly what I'm saying." And so I don't have time to do it during that deposition, but I go online, Amazon.com, before I forget, during our depo break, I order it, and I go through it, and there's actually a part in there that says something like, over the years there's been interest from lawyers, insurance companies, and other people as to whether or not you can tell by looking at an MRI as to whether something was caused by trauma or not. And it says it is without scientific or medical basis to date the herniation. And it basically said unless you have a prior MRI, you cannot tell by looking at the MRI whether it was caused by trauma or not. It was the exact opposite of what he said.
Right.
And then, next depo I had with him, I pulled it on him, and he just started. And now whenever I do it, he just says, "Data herniation, I'm not trying to go out with it," and and just evades the subject, and he looks like a total liar. Now they don't use him on our cases anymore.
Well, I mean, I think that you make a good point. It's not all stuff you're going to get in that one deposition, and some lawyers out there listening to this podcast don't have the benefit of a report. There are some jurisdictions where you don't have the report in front of you to scour, and you've got to do it. You've got to get this information in the deposition, like what authorities they rely on. And of course, there are those experts that will say it's their own experience that they're relying on. And the astute lawyer is going to be able to take advantage of that. I had a doctor, psychiatrist, who was offering the opinion that my client's sexual assault wasn't the source of the long-term depression and anxiety that she was having several years following her rape. And he didn't have any authority, any book or paper that he could cite to for this opinion of his. So what he based it on was his own personal years of experience in evaluating and treating rape victims and rape survivors. And so I went with him on that and asked him for the details of some of the cases that he'd been involved in. And they were pretty graphic, and they were very traumatic situations. But ultimately, his conclusion, because of his experience, and we got him, he said this on the record, his conclusion was that my client's rape wasn't that bad by comparison. And it was a horrific thing for him to say under oath and recorded on videotape. And as you might imagine, the case settled shortly thereafter. But sometimes if you're facing a witness who is going to stand firm on his or her opinion that it's that way because I said so, you'll never know until you dive into why do you say so? Tell me what the difference is. And so they were very uncomfortable conversations about sexual assault victims and survivors that he'd dealt with in the past. But if I hadn't been willing to just follow that trail where it led, he wouldn't have been so frustrated with me at one point and saying at the end, that my client's sexual assault wasn't that bad by comparison. But it provided a perfect soundbite for negotiation purposes.
Oh, absolutely. And I'm sure he wasn't used very often by that lawyer after that.
No.
For good reason.
We'll return to part 2 of this podcast in just a moment. Each year, the law firm of Cowen, Rodriguez, Peacock pays millions of dollars in co-counsel fees to attorneys nationwide. Are you an attorney with a catastrophic injury or wrongful death case you'd like to discuss with host Michael Cowen? If so, you can reach Michael by calling 210-941-1301 or send an email to michael@cowenlaw.com. We now return to the rest of this episode of Trial Lawyer Nation.
Now, I've noticed I kind of have two schools of defense paid opinion witnesses. There's the ones that are total advocates for the defense and will do whatever they can to help them no matter what. And I found the other ones that to try to help, they play these semantic and definition games, but if you get past those, you can kind of turn them into your witnesses. So you'll have a doctor saying, well, when I look at the MRI, this is all degeneration, and most people have degenerative changes. That's all true. Those are all true statements.
Right.
That most of our clients' MRIs have degenerative changes on them because most human beings have natural aging and have degeneration. But when you go, some of those doctors, you can ask them the questions like, almost everybody over the age of 25 or 30 is going to have degenerative changes. Yes, that's natural aging, yes. Degeneration is normally not painful. Yes. Degeneration normally does not require surgery. Yes. Now, you could have someone with degeneration or natural injury and then expose them to trauma, and that could cause those conditions to become painful. Yes. And sometimes if you have pain plus degeneration, you do need surgery. Yes. You're not aware of any evidence that my client had any pain the day before the crash, are you? No. You're not calling my client a liar, cheat, or fraud? No, I'm not. Okay. Do you have any reason to believe that she has not had pain ever since? She says she did. Yes. It's in the medical records. Okay. So the evidence we have is no pain before. Correct. There's pain ever since. Yes. And trauma added degeneration can cause those degenerative changes to become painful. Yes. And sometimes they even go with, so you would agree the most likely cause of my client's pain is the crash? Yes, I'd have to agree with that. They'll begrudgingly. And sometimes you'd even get, now the pain is a reason for the surgery. Would you agree that but for the crash, my client would not have had the surgery? And sometimes they'll say, well, I don't think the surgery was necessary anyway. But okay, but the reason that it was done was because of the pain that was caused by the crash. And sometimes you get them to agree with that, and you end up actually playing their deposition as part of your case in chief.
Well, the point that I think that you make is that with respect to defense opinion paid expert witnesses, is that you can never take that deposition with a broad stroke. You've got to be able to drill down on one word and one definition and tease that out just so carefully and artfully. And then if you do it right, you can use that testimony to your advantage, because at the end of the day, there are some terms they can't disagree with. I mean, there are some medical terms that they have to agree with because it's in the medicine. But going into these depositions with a broad brush, you're not going to get that testimony. You've got to be patient, and you've got to plan meticulously to be able to go do the line of questioning that you just gave an example of.
You do, and you have to listen for openings, and you have to realize, is this somebody, because I want to take them down one or two roads. I want them to get them to agree with me and become my witness, or I want to paint them as so extreme that they'll say every doctor in the case committed malpractice, that they should all be reported to the medical board, and start naming other doctors in other cases, so that someone on the jury is going to have been treated by some doctor he says commits malpractice and is a horrible doctor, get him to disagree with everybody else. So I want them either one extreme, that they're just way out there and they're obviously paid advocates, or I want to turn them and try to turn them into my witness. And you don't know, with some because you deposed them before, but when you're going in there, you have to have a game plan where you're, okay, this is what I'm going to do if they'll give it to me, this is what I'm going to do if they don't give it to me. And then not be just looking at your notes and going question by question, but listening to what's not said, listening to the little pauses, looking at facial expressions and saying, okay, what's this witness going to do if I go here or there? And sometimes you get it wrong, but so what? It's a depo, you edit it. Right. It's kind of like a podcast. Right? When we screw up, we just record over that part. And
well, the one thing that you made a note of is that in our previous talk on the podcast, I talked about how this is the place to, sometimes when you take a deposition, you put your pen down and you listen carefully. Preparing for a medical defense paid witness, you're walking in and you're never going to be able to know as much as they do about the medicine unless you're a doctor yourself. And so I think one of the ways that I've prepared to overcome that intimidation factor is you call up your doctor, you take in the questions you have, and you have them help you poke holes. So when you're going into the deposition, you have an outline, hopefully, of what your own doctors, consultants have already told you are weaknesses in those opinions. So you're walking in with a specific game plan. So, when I'm talking about going in prepared, it doesn't mean just pretending to practice medicine for the next 3 days in preparation for a deposition, but it also means consulting with other doctors, consulting with other experts and other lawyers who've deposed that doctor so that you know where the weaknesses are.
Now, sometimes they ask to examine our clients. Some states, they have the right to do it. Texas, there's actually, they may or may not have the right to do it, and the different standards in federal and state court. What is your approach to that when someone asks, hey, we want our paid opinion witness to examine your client?
Well, one of the very first things, and it should be a knee-jerk reaction for everybody, is that the defense is going to call it an independent medical exam. And so we know right away that we'll never refer to it as an independent medical exam because it isn't at all independent. It's a defense-paid opinion, and so we don't refer to it as an independent medical exam. But the other thing that you should always do is never, if the jurisdiction doesn't require it, then you should always put up a fight, because walking in, the only thing that's going to come of that is a negative opinion for your client. So making sure that the defendant lawyer is going to meet every requirement that the court has to allow them to have the exam, and then asking the court for certain protections for your client when that exam goes forward. We've seen some examples where the court will require a very detailed explanation of exactly what examination will take place, how long it will take place, who can be there. We've also had some requirements that the court will allow us to videotape the examination to ensure that what the doctor is saying he or she is doing is actually what is done. And I've actually attended some medical examinations of my clients so that I'm there and I can provide some semblance of a protection and observation of the exam.
Yeah, I find it very telling that more than half the time when we fight them because of the Texas rules, and I know there's a lot of our opponents that listen to this podcast, so I'm not going to go into what they have to do, but there's a burden of evidence they have to meet. Defense lawyers aren't used to having to meet a burden of proof, and they often fail to meet it. So about half the time it just gets denied. But when it gets granted and we've got a judge to order that it be videoed, the vast majority of defense paid opinion medical witnesses will not do an exam if it's videoed. And to me, that's very telling. If it's videoed, why won't they do it? Because the truth is they don't do the exams that they say they do, or when they do them, they don't accurately record the findings. And they know they're going to get caught, and they just refuse. One other thing that I've found useful is that I found some of these, because they're not acting as doctors or acting as paid advocates for the other side, is they will take what they call a history, but they will go into great details about how the wreck happened, go into liability issues, go into all kinds of things that have nothing to do with their medical opinions. And I just put it this way, Judge, what they want to do is basically do a deposition of my client, except with no lawyer present and with no court reporter present, where the defense lawyer, imagine if this doctor was a defense lawyer, they want to go in a room alone with my client, ask them questions, and they write down the answer with no verification as to whether that's what my client really said. And we've had cases where one particular doctor doesn't speak Spanish, is not for just me, but other people, other lawyers I know have had clients that when there was not a sufficient court order in there, has had these people evidently confess to him, oh, I'm not really hurt, I'm not really in pain, but every other medical record says they are. The client says, I didn't say that. And so, but then it's our client's word against the doctors, and until we go bring in the other people from other cases, but we've been able to use that to get the doctor to limit, what he talks about, and in that particular person, not let them be there without someone taping it, a certified interpreter, because he gets things wrong. How does he know that someone who happens to work for him is going to interpret the Spanish correctly? if that person's not a certified interpreter. So we've done a lot of good. And what happens with him is, if you acquire an interpreter, he won't do it. If you have a video, he won't do it. Why? Because he's a liar.
Well, I think that by and large, even if a judge isn't going to order a videotape for whatever, allow the exam to be videotaped for whatever reason, you make the exact argument for why the lawyer should at the very least be allowed to be present, because if it should not be a second deposition or a deposition of your client without their lawyer present.
The only problem about going yourself is then, if you have to be a witness, then you can get conflicted on the advocate witness rule. So maybe if you have someone else you work with, a paralegal. I know some people hire nurses. I've never actually done that. I've heard of people doing that, to attend. But some things, like you and I wouldn't know, like if they do an exam and their leg's supposed to twitch one way and it does or doesn't twitch that way, we wouldn't know.
Right.
But if you get it videoed, and then there's people that can watch that for you. I know Dorothy Sims has a service where she'll have a doctor review the video and see, did the doctor do what the doctor claimed he or she did? Did the exam show what the doctor purports that it showed? And it's not that expensive, and that's something that when you get the video you can do. And the other thing is just to listen to what's said. Sometimes what's said and what's written down are very different.
Right.
Another thing, when you're examining the doctor, we hate them often. I mean, because we see them again and again and again. We know what they are, but the jury doesn't. So how do you approach tone-wise and when you're doing the cross-examination of the defense doctor to avoid turning off the jury and looking like a mean person?
Well, I don't think I'm naturally a mean person, so I just try to go in there and be as polite as I can, and being mindful of the fact that the jury is going to be seeing this witness for the very first time, even if you've seen them, year after year. But also being mindful of the fact that the jury is still judging you, and if you come off as a jerk or a bully, or keep cutting off the witness in the middle of a sentence, it's going to come through. And so, I think that the reality is that we've got to take these depositions mindful of the fact that there's a possibility it's going to be played back for the jury.
Absolutely. I know, at least in Texas, the defense almost always just videotapes their own expert, and so your deposition is your trial cross. And I think demeanor, tone of voice is so important, because we need to very nicely and politely tell a story in our cross-examination that leads the jury to their own conclusion that this is a bought and paid for person, that leads the jury to their own conclusion that they and their families are actually in danger if paid opinion witnesses can get away with allowing companies to harm people and then get away with it because they can pay money to get someone to get them out of it. But they have to get their own conclusion. So when we just go rip into them, it doesn't work.
I agree, and I think that today's jury is a little bit tired of theatrics and overly enthusiastic lawyers, and so the idea of letting the jury reach their own conclusions with the information that you give them, or that that you can elicit from the witness, is much more effective than pounding on the table and yelling and getting in a witness's face.
And especially on video, it just comes across as very shrill.
Right.
But we still need to tell the truth. When they came in there and said, "Why did an independent medical exam?" and you start off, "Well, you say it was independent, but they picked you. The defense picked you." And and I even try to use a word other than defense. Now we can't use insurance company. But the almost all your work is for the people that hurt somebody, that caused a crash, and don't want to pay money to the person that got hurt. Or
corporations,
or whatever it is. But I used to say, most of your work is against patients. It's someone, they were in an incident. They say they were hurt. Their treating doctor says they were hurt, and then you get hired by the person who does not want to pay money to the compensation of the person whose own doctor says they're hurt, and that's where you get hired. Because people they get plaintiff and defense and all that stuff.
Yeah, they don't know the
confused.
difference.
And so you say that it was an independent medical examination, but the judge didn't appoint you. The party that doesn't want to pay, the defendant, they picked you, correct? And they paid you for this, for the time doing the examination, and they paid you to write your report, and they're paying you to be here today. So it wasn't independent. They picked and paid you. And that picked and paid for is something else that I got from Keith Mitnick.
What do you do when you have picked and paid for on your side? Because you're critical of them for being picked and paid, then you have your own picked and paid.
Well, that's why when we make sure with our expert witnesses that we establish what we call anchors, that we show that our people are following scientific rules, our people are supported by good literature and methodology.
I think that you have to make sure that if you're going to be critical of a defense paid opinion witness, you need to make doubly sure that your witnesses got their T's crossed and I's dotted.
Absolutely. But the other thing is, ours are usually supported by a lot more. Our doctors will say, as far as I know, there was no pain before, there's pain afterwards, therefore the most likely causes the pain. That's a pretty easy opinion to accept.
Mm-hmm.
It makes sense. When our doctor says, yeah, everyone has natural aging, but usually don't need surgery for it. That's a pretty easy opinion to accept. And then when we bring in 5 other people, yes, I worked with this person for 4 years, and every day at work before the wreck they seemed fine. In fact, after work we do X, Y, and Z together, and then I can tell that they were different afterwards, and here's the things they couldn't do, and here's what I've seen on their face. And we have other evidence supporting what our doctor is going to say. And also, I think there's a difference between being. Sometimes I know what you're saying. Sometimes we hire paid opinion witnesses too. But I don't care. I just let them attack ours. I'm still going to attack theirs and show them for what they are. And then hopefully, like I said, ours we have backed up, so we're not relying on their credibility, but we're showing their work. We're showing that they have some kind of literature or study or something behind what they have to say. Sometimes treating doctors, you don't get that, but they are a treating doctor. They are doctors in the community treating patients, right. And this is what they do. So I just don't even worry about that. I think the last thing just to remember is, you can't look at the defense opinion witness examination in isolation. You have to have a big plan for your trial. So, for example, if you have that article or that book chapter that absolutely contradicts what they're going to say, you can't rely on them to recognize it as authoritative so that it becomes a learned treatise under the rules. You need to make sure that you have a plan with your doctor, that your doctor is going to prove it up and give the foundation as the learned treatise so that you could go and do that. And an example is the case that Mallory and I tried last year, and our client got a broken leg because she stepped off a bus and the bus driver had not deployed the step. And after she gets off, someone hits the button, the step comes out, hits her in the leg. Because she's an older woman and her legs are weak, it breaks really badly. And the defense had a biomechanical expert and a medical doctor, both of whom said, no, because of the characteristics of this fracture, it had to be from her stepping down and stepping wrong, not from something hitting her on the side of the leg. And we worked with our people, and it was what's called a transverse fracture. And our doctor found a book that was a well-established book on broken bones that says a transverse fracture is one caused by a perpendicular load, which is a load that's coming from the side, not going up and down like when you step. And so I had proven that up with my doctor, and also there was something else called ecchymosis where we proved it up. We were fighting about what it meant, and we'd proven up the medical dictionary with my doctor when they were on direct, so that way I could go and cross-examine, and then show the jury that the books, in this case, both of them they admitted having in their library, said the opposite of their opinion, and then they had no literature with them to support their opinions. And it was a lot of fun.
I think that goes back to the point that we were both making earlier, is that these depositions are a long game, and you can't go in and think you're going to capture some aha moment or Perry Mason opportunity with this witness. Sometimes all you're doing with the defense paid opinion witness is simply laying the foundation to highlight your own witnesses, your own doctor's testimony, to criticize them, or showing what they don't know or what they don't have. And it's perfectly okay sometimes to walk out of a defense paid opinion witness's deposition knowing that you didn't get some aha moment, but you laid the building blocks to be able to crush them later with your own witnesses at trial.
And at the end of the day, I've lost cases for many reasons. I do not believe I have ever lost a case because of what a defense paid opinion witness says, because people know that people who are getting paid money to testify in lawsuits are not credible. And as long as we're not afraid of them and we do the work to expose them, even if we don't have our aha moment, they're usually not very effective. And I think people get way too worried about them when the juries are really good about seeing them for who they are.
Right.
Well, Sonia, I think that's a wrap for today. I've really enjoyed talking to you.
It's been fun, Michael.
And I hope this was useful to you. If there are any other topics you'd like to see us discuss, please email us, and we'd be glad to talk about them. Thank you for joining us today on Trial Lawyer Nation. I hope you enjoyed our show. I always love hearing from you, so please continue contacting us via email at podcast@triallawyernation.com or send us a message through our Trial Lawyer Nation Facebook page. Maybe your question will be the topic for our next Table Talk conversation. Don't forget to visit our website at triallawyernation.com to opt into our mailing list and stay up to date on our new episodes. Lastly, we now have a private group called Trial Lawyer Nation Insider Circle on Facebook. This exclusive group will allow you to hear about podcasts before they air, interact with the show, as well as get a sneak peek at some of the behind-the-scenes moment. If you have a Facebook account, be sure to send us a request to join the group. Thank you for tuning in, and I look forward to having you with us next time on Trial Lawyer Nation.
We look forward to talking with you again soon as we continue to explore powerful insights from our amazing host and remarkable guests here on Trial Lawyer Nation. Until then, please be sure to subscribe and review this podcast on iTunes or your favorite listening app so we can continue to reach more listeners. Visit us at www.triallawyernation.com to send us a message, listen to previous podcasts, or learn more about Michael Cowen and our guests. This podcast has been hosted by Michael Cowen and is not intended to, nor does it create the attorney-client privilege between our hosts, guests, or contributors and any listener for any reason. Content from the podcast is not to be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.